With international trade and investment steadily on the rise in the country, there is a need to provide to provide a robust and internationally competitive platform for resolving disputes. The Arbitration and Mediation Act 2023, which was signed into law in May, is not just another legal update, but a transformative blueprint that seeks to strengthen Nigeria as a preferred destination for arbitration and mediation. And Nigeria winning the $11 billion P&ID case, this has further cemented that the country has a preferred destination, of course, for investment. Let's get talking. And the registrar and chief executive officer of the Nigerian Institute of Chartered Arbitrators, Mrs. Shola Oshodi-John. She's live in the studio to talk to us more about this. Good afternoon. It's good to have you on the show.
Good afternoon.
It's your first time on the show. Thank you for coming.
A pleasure.
Yeah. I'm going to start with the $11 billion case. You know that. The P&ID thing. It's really, really, really big. There seems to be, it's good news to everyone. But you, what would be your reaction to it from your institute and from your personal views on this?
Well, for us as an institute, Nigerian Institute of Chartered Arbitrators is a welcome development. This is something we've been pushing for the past 5-6 years as an institute, trying to collaborate with the federal government to see how we can also be a part of the team, provide pro bono services. But unfortunately, during the last regime, it didn't work out. But this is one area that I believe that Nigeria needs to begin to look at, putting our best foot forward, trying to ensure that the expertise that we have locally, is a nest to ensure that we never should have a case like this again.
True. We shouldn't.
Never.
We shouldn't. Let's talk about the Arbitration and Mediation Act 2023. For me, I think, do you think that addresses all the gray areas? Because there are always issues.
Well, first of all, let's say it's a good development because that act, the old one was there for like 30-something years. It's so old. And presently, the new act is forward-looking. So I believe a lot of the issues will be addressed by, or has been addressed by the new act. But you and I know that it's not about the act. It's about implementation.
True.
And it's also about the users of the act. And so you can have a very beautiful laws and the users frustrated. So what can you do? So, but having said that, is a good act because now Nigeria is at par, globally as an arbitration destination, and our laws are up to date to a large extent. We have a lot of new provisions that makes Nigeria a friendly and arbitration-friendly state for others that would like to come to Nigeria as, to use Nigeria as an arbitration point of destination. But again, the enabling environment is important that we get it right, ensuring we have the enabling environment. And that starts from, our court systems, how fast, how well and how good we are when it comes to the issues of enforcement, when it comes to the facilities that we have. Do we have standard international facilities that can host, international arbitrators? Do we have, right now, our economy is struggling. Do we have fiscal policies that also will support the growth of arbitration? So there's really a lot that you need to do to put in to become an arbitration destination for other nations, other state parties as well. And this is what Nigeria is looking at. So for us as an institute, it's a welcome development. We are very excited about the new act because also the new act gives Arbitration Institute, that like the Nigerian Institute of Chartered Arbitrators Arbitration Center, we have a center to be able to do a lot, unlike in the past where we were just rendered sometimes functions officials where we really felt we needed to act because the old law didn't give us those powers. So a lot of the practice in arbitration today has now been enacted as law. So it's not a question of, it's just a question of, is the practice, but now it is the law, and you have to comply with it. One of the first things that excites me about the act is talking about binding nature of arbitration, talking about the irrevocability of arbitration agreements, and those for me are sacrosanct when it comes to arbitration. So it is no longer it's no longer an option, but it's a finality. If you choose arbitration, you have to go through arbitration. But you're talking about arbitration, I can say a lot about arbitration, but I also want to say something, and what I want to say is that arbitration is not when you go to the tribunal. The P&ID matter, I'll take you back to the P&ID matter. It wasn't the issues did not begin at the tribunal or at the courts. The whole issue that Nigeria had to grapple with started from the point of drafting of the contract.
Yeah.
And you saw it at play.
Yeah, that's true.
So when we talk about arbitration, it is not at the point where you go to the arbitral tribunal. Arbitration starts from when you draft the contract. Unfortunately, in Nigeria, not much attention is paid to drafting of contracts where you have arbitration clauses, particularly at the government level. And I can tell you that there are so many other arbitration matters like this that the federal government is contending with. And so some we will lose, some we will win. But I believe as an institute and also as someone that is in the arbitration space, we need to start by getting our acts right from the very beginning. That is at the point of drafting. Employ, engage professionals, experts that has specialized skills when it comes to negotiating contracts on behalf of the state. Don't just put people there because they know somebody or because it is good for them to do, or because they are maybe directors of ministry with due respect and so they qualify. No, it takes specialized skills to be a good negotiator, to be a good contract administrator. So those are the things that Nigeria needs to begin to put in place. And like I said earlier, we need to also now look inwards. Let us begin to appreciate our homegrown arbitrators, our homegrown professionals, because for so many years we have neglected what we have and we had continued to think about importing. We export arbitration matters out instead of using local experts. And arbitration is a skill, it's an act. If you do not put money into it, if you do not train people, it's like an apprenticeship. They are not going to be very good at it. So the time has come for us to begin to think about developing our own capacities, technical capacities, so that when we have arbitration matters, like before they even get to this level, we know what to do, we know how to handle it. And this is part of what we are doing